The UK Constitution was famously described as an elective dictatorship. But what does this mean, and is this a bad thing? Does the country that is often considered to be the birthplace of modern parliamentary democracy really have no separation of powers? In this video, I'll outline the idea of the separation of powers before discussing in further detail the separation of powers between the legislature and the executive in the UK. I'll leave the separation of powers between the judiciary and the other branches of government until the next video in this series. First, it's important to set out what we mean by a separation of powers and what the purpose of this idea is. Writing in the 18th century, the French judge, historian and political philosopher Montesquieu famously described the dangers of vesting absolute power in a single individual or institution. When the legislative and executive powers are united in the same person or in the same body of magistrates, there can be no liberty, because apprehensions may arise lest the same monarch or senate should enact tyrannical laws to execute them in a tyrannical manner. There would be an end of everything were the same man or the same body, whether of the nobles or of the people, to exercise those three powers, that of enacting laws, that of executing the public resolutions, and that of trying the causes of individuals. The separation of powers, therefore, is the very simple idea that powers should be split up amongst different institutions, and that these institutions should check and balance each other. Montesquieu's writings were very influential on the US founding fathers, with James Madison famously remarking that the accumulation of all powers, legislative, executive and judiciary, in the same hands, whether of one, a few or many, and whether hereditary, self-appointed or elective, may justly be pronounced the very definition of tyranny. And yet Montesquieu can hardly be credited with thinking up this idea in Western political thought. All the way back in ancient Greece, writers like Plato and his student Aristotle were concerned at the stability of various political systems and how the power they wielded could produce tyranny. Plato's famous study of the various types of government, his 5 regimes, notes how each form of government eventually decays into another form of government as its internal contradictions and propensity for abuse of power come to the fore. In contrast, writing some 200 years after Plato, the Roman statesman Cicero lauded the constitution of the Roman Republic as by far the best constitution. The genius innovation the Romans stumbled upon was rather than have one form of government eventually decay into another, elements of these various different types of government should be present at the same time, with each checking the other. In very simple terms, the classic power of a monarch possessed by the elected councils was checked by the strong advisory power of the Senate, which represented the aristocracy, and their powers were in turn checked by the People's Assembly, who voted on laws in the legislative assemblies. Now, unfortunately, Cicero was lauding the genius of the Roman Republic's constitution right at the very moment that it was collapsing, and just a few short years before Julius Caesar was appointed dictator for life and triggered a civil war that would eventually lead to the rise of the autocratic Roman Empire. Today, rather than split power amongst consuls, senate and people's assemblies, constitutions tend to divide power into 3 broad categories: legislative, executive and judiciary. I will record separate videos on all these powers later in this series, but essentially the legislative power is the power to make the laws, the executive power is the power to enforce the laws, and the judicial power is the power to interpret the law and to adjudicate upon legal disputes. The separation of powers theory also requires that each of the powers can check and interact with the others to ensure that they stay within the bounds of their power, and it is this interaction between the powers that controversy can arise. In terms of the separation of power between the legislature and executive, in democracies today we can identify 2 broad categories of constitutional arrangements: presidential and parliamentary democracies. There are also semi-presidential systems like France, but we won't go into that in detail here. In presidential systems, the personnel that make up the executive are usually completely separate from the legislature. So, for example, the US president is elected separately from its bicameral legislature, which is made up of the House of Representatives and Senate. If a sitting congressperson or senator is elected as president, as was the case with Barack Obama, they must vacate their seat. Likewise, anybody who the president appoints to their cabinet would also vacate their seat. The current US Secretary of State, Marco Rubio, for example, had to vacate his seat as senator for Florida. As presidential presidential elections are separate to congressional or senatorial elections in the US, it may not necessarily be the case that the same political party holds a majority in both houses of Congress and the presidency. Relatedly, legislatures may be more independent-minded, as their electoral success and career prospects may not be completely dependent upon loyalty to the party leader or president. For this reason, politicians voting along party lines in the US has traditionally not been as strong as in other countries like the UK. I say traditionally, as despite the apparent strong separation of powers under the US Constitution, many commentators are highly critical of Congress's failure to exercise any constraints on the presidency of Donald Trump so far. In contrast to presidential systems, in parliamentary systems, the executive is drawn from members of the legislature. You cannot be a member of the executive unless you are a legislator too. In the UK, the Prime Minister, the head of the executive, is the leader of the political party best able to command a majority in the House of Commons. This is a rule of convention rather than being required by law. If you want to know more about conventions and the British Constitution, I've recorded a separate video on this and I'll leave a link in the description below. As the Prime Minister should, by definition, have the support of more MPs than any other party leader, this means that the executive can heavily influence the work of Parliament. In fact, it is usually the case that the Prime Minister can command a majority of MPs, and this means that, in theory, the government should be able to get any piece of legislation it wishes passed by the House of Commons. So, for example, in the 2024 general election, the Labour Party won 411 out of 650 seats. Prime Minister Keir Starmer therefore can potentially rely on the support of over 60% of MPs, making it difficult for the House of Commons to act as a brake on the government's wishes. The government also exercises strong control over House of Commons business. Government business is given priority over what are called private members' bills, and the government can use programme motions to set out how much time MPs will have to debate on legislation. The government also has control over the power to prorogue Parliament. More on this power later. In addition to the Prime Minister, all other government ministers and junior ministers are MPs too. Some may also be members of the House of Lords. In 2023, for example, David Cameron was made a member of the House of Lords by then Prime Minister Rishi Sunak so that he could be appointed Foreign Secretary. This can raise questions of democratic legitimacy, however, as it meant that the Foreign Secretary at the time held no democratic mandate from a constituency, nor could he be held directly accountable at the next general election for his actions. The number of MPs drawing a government salary can be substantial, with the Institute for Government suggesting that some 163 MPs may be part of the government paywall vote. This means that the government should be able to rely on these MPs to vote in their favour. If they fail to do so, they should resign or be sacked. In order to ensure that MPs who aren't part of the paywall vote support the government, they will use what are called whips, MPs tasked with enforcing the party line. Whips can use a variety of tactics to incentivise, cajole or pressurise these backbench MPs to toe the party line. The most severe of these is the 3-line whip, which can lead to an MP being expelled from the parliamentary party and forcing them to sit as an independent if they vote against the government on a specific issue. It is this usual dominance of the executive over the House of Commons business that led Lord Hailsham in 1976 to declare the UK as an elective dictatorship. Today, the centre of gravity has moved decisively towards the government side of the House, and on that side to the members of government itself. The opposition is gradually being reduced to impotence, and the government majority, where power resides, is itself becoming a tool in the hands of the cabinet. Backbenchers, were they to show promise, are soon absorbed into the administration and so lose their power of independent action. For this reason, therefore, we can conclude that the separation of powers between the legislature and the executive in the British Constitution tends to be quite weak. However, a lot of this depends upon parliamentary arithmetic, and on rare occasions a general election can throw up a result in which no political party controls the majority of MPs. This can tip the balance in favour of Parliament, making it difficult for the government to implement its legislative agenda. The 2017 general election, for example, saw the Conservative Party win 317 seats, 9 seats short of an overall majority of 326. A confidence and supply agreement with the Northern Irish Democratic Unionist Party soon collapsed, and the minority Conservative government struggled to get its legislative agenda through Parliament. Brexit dominated this Parliament, with many Conservative government supporting MPs joining in with the opposition parties in opposing Brexit. Parliament therefore was in the unusual position whereby it could frustrate the government's agenda and potentially even pass legislation which the government opposed. A change in Prime Minister with the resignation of Theresa May and the appointment of Boris Johnson brought this impasse to a head. In August 2019, Johnson advised Queen Elizabeth II to prorogue Parliament until a new parliamentary session would begin on the 14th of October. Prorogation marks the end of one parliamentary session and the beginning of a new one. The legislative agenda is wiped clean, and when the new parliamentary session opens, the King reads out a list of bills which the government proposes it will pass. Prorogation usually lasts just a couple of days, but in this case, Parliament would not sit for 6 weeks. This led many to speculate that the reason behind the lengthy prorogation was to stop Parliament from having sufficient time to pass legislation that would block the UK's automatic exit from the EU on the 31st of October 2019. So in effect, we have a clash between Parliament on the one hand and the executive on the other. Needless to say, many MPs were outraged at this, and several took a case to challenge the legality of this lengthy prorogation. The judiciary was being asked to resolve this clash between Parliament and the government. In the Miller-Cherry case, the Supreme Court defended its legitimate role to decide the case, relying on the separation of powers to do so. If the issue before the court is justiciable, deciding it will not offend the separation of powers. The court will be performing its proper function under our constitution. Indeed, by ensuring that the government does not use the power of prorogation unlawfully, with the effect of preventing Parliament from carrying out its proper functions, the court will be giving effect to the separation of powers. So the court could decide whether the prorogation was lawful. It was, as we say, a justiciable question. On this issue of whether the prorogation was lawful, the Supreme Court laid down a test that also reflects the separation of powers. A decision to prorogue Parliament or to advise the monarch to prorogue Parliament will be unlawful if the prorogation has the effect of frustrating or preventing, without reasonable justification, the ability of Parliament to carry out its constitutional functions as a legislature and as the body responsible for the supervision of the executive. In such a situation, the court will intervene if the effect is sufficiently serious to justify such an exceptional course. In this case, the court found that the government had produced no reason for proroguing Parliament for such a long period of time. In reaching this conclusion, the court clearly distinguished Parliament from the government, and emphasising that Parliament's constitutional function is not only to pass legislation, but also to supervise the executive. The result, therefore, was that prorogation was unlawful. The Brexit impasse was eventually resolved when the government secured enough support from MPs to dissolve the House of Commons and call a general election. In December 2019, Boris Johnson returned to power, but this time with a majority in the House of Commons, and so he was able to secure Brexit through this new parliamentary arithmetic. So when it comes to the separation of powers between the legislature and the executive, we can say that usually in the British Constitution, this separation is weak and the executive usually dominates the legislature, but not always. So is this a good thing or not? I like to put it like this. The advantage is governments can get things done. The disadvantage is governments can get things done. Contrastingly, regarding presidential systems where a president may or not have a majority in one or both houses of the legislature, the advantage is the government cannot get things done. The disadvantage is the government cannot get things done. So in essence, a lot depends upon your own particular perspective on the government's plans. I hope you found this video helpful. While I focus mostly on the separation of powers between the legislature and the executive in this video, in the next one, we'll discuss in greater detail the separation of powers between the judiciary and the other branches.